first session we're having
This meeting is
on,
being recorded.
I just want to welcome everyone to this first session we're having on intellectual property for the physician scientists. This is born out of the resident fellow and junior faculty session to bring some more insight to our trainees about actually how to protect the property that they are discovering in the laboratory and how to make relationships that will bring that technology and discoveries to the marketplace. So I'm very pleased to be here. My name is Evan Nock, and I'm an assistant professor of neurology in the Division of Neuro-Oncology at Weill Cornell Medicine, and I'm co-hosting this with Jennifer Kwan. Jennifer, introduce yourself.
Yes, hi. I'm a cardio-oncology fellow this year, but will be joining Yale as faculty this coming summer as a physician scientist track faculty member.
Great. So thanks everyone for joining today. First up, we'd like to take a minute just to have a moment of silence for those suffering from the tragedy in Ukraine, and our hearts go out to everyone over there who's dealing with the war that's currently taking place. All right, well, I'm gonna go ahead and introduce our speakers for today. So first we have Dr. Susie Chang. So Dr. Chang obtained her BA from Hunter College from the City University of New York and her PhD from Columbia University before completing her postdoc at Rockefeller and her JD at Brooklyn Law School. She's a partner and member of the Biotech and Pharma Group at Leeson Ellis, and she focuses on all aspects of US and global strategic patent protection, licensing of inventions, and monetization of intellectual property. Her services include due diligence investigation of patent portfolios, products, and involvement in legal proceedings for investment, licensing, and acquisition opportunities. Her clients operate in a wide range of technologies, including artificial intelligence, algorithms in healthcare, pharmaceuticals, biotechnology, cannabis, biometric authentication, medical device, and nanotechnology. For clients doing business in China and those from China, her fluency in both Cantonese and Mandarin Chinese makes her a highly effective advocate. Jason Johnson obtained his BS from UNC Chapel Hill and his JD from Franklin Pierce Law Center. Jason is a partner in Moses and Singer's healthcare, privacy, and cybersecurity and intellectual property practices. The focal point of Jason's practice is counseling clients on the complicated regulatory and compliance issues related to the privacy and security of data under US and European laws, and complex transactional matters related to product development, marketing, clinical research, and business matters. Jason brings his extensive experience as a benchtop research scientist in the academic and pharmaceutical environments to the representation of his clients, which includes academic medical centers, healthcare technology companies, pharmaceutical and medical device companies. Jason is a registered agent with the United States Patent and Trademark Office with over 11 years of experience as a patent litigator. His substantial experience in the intellectual property landscape enables him to evaluate and implement the best strategic business strategies for his clients' copyright and patent protection needs. Mary Howard founded and currently leads the metro area scientist and engineer-led entrepreneur education and networking programs eLab NYC, Next Milestone, Accelerator for Biosciences in Connecticut, and Westchester County Biosciences Accelerator. The over 275 venture alumni, which represent breakthroughs in therapeutics, digital health, medical devices, diagnostics and materials, and spin-outs from major institutions like Columbia, Weill Cornell, NYU, Rockefeller, MSK, Mount Sinai, CUNY, SUNY Downstate, Cold Spring Harbor, Yale, and UConn, as well as Roche, Pfizer, and Medtronic. These alumni have collectively raised over $2.1 billion over the past 9 years, with multiple innovations in clinical trials, acquisitions, and IPOs. These competitive entry community-supported programs are free of charge to all accepted and offer unique support opportunities both within the program and beyond. So please join me in welcoming our speakers for today. So with that, we're gonna have Susie give a presentation on her perspective on intellectual property for physician scientists. So Susie, I'll stop sharing my screen and then you can share yours.
Okay.
Can you see the screen?
Yes.
Mhm.
Okay. Well, good afternoon, everybody. Thank you. Ethan asked Jason and I to do a high-profile patent case study that would be of interest for this group. And I picked the genome editing technology of CRISPR. I'm just wondering whether you in the audience have read this biography of Jennifer Doudna. I'm not affiliated with the publisher of this book, but I figure that this will be a good starting point for us to discuss basic research and the crossroad with patents that protects the fruit of the labor of scientific endeavor. I will be illustrating different type of patent issues and using CRISPR as an example. And I would also, because of the so many players in the CRISPR technology, I will be illustrating the example using specifying in two groups. And it would be, the first group would be, I would refer it to the UC group, Jennifer Doudna and Emma Charpentier, who are the recipient of the Nobel Prize in Chemistry in 2020. And the other group is where Feng Sheng is an inventor, the Broad Institute. With this group, I don't believe that I need to go into the details for CRISPR technology. So as a research scientist, if you would like to know whether your invention or the research that you are doing has already been patented or whether a patent application has been filed or not, you could go to the USPTO website, uspto.gov, and do a search. For example, if we do a search as Doudna as an inventor under Cas9, we found that there are over 76 US patents. In fact, at this time, there are over 6,000 US patents that are related to the CRISPR technology. And also every month, there are over 200 patent application that is being filed with the US Patent Office related to CRISPR technology. And the applicants are mostly from the United States as well as in China. With regard to patent rights are not a right to not a license right, not a license to practice your invention. Rather, patent rights are exclusionary rights where you exclude others from practicing your invention. There are many different criteria to determine whether an invention is patentable or not. We will refer a few here. What we refer to as 102 is whether your invention is new, whether the examiner could find one single reference or publication that disclose your invention. Another criteria is what we refer to 103, meaning that whether your invention would be obvious when you combine multiple publication or references. Does it arrive to your invention? Another criteria which becomes a big hurdle for the past 10 years and continue to be a big hurdle is what we refer to 101, the subject matter eligibility. Not all subject matter are patentable. For example, subject matter that is an abstract idea, physical law of nature or natural phenomenon, they are not patent eligible. In the field of biotechnology and pharmaceutical, if you your invention is a marker, a genetic marker, and you found a correlation between this genetic marker with a disease or disorder, it is facing pretty high hurdle with regard to this subject matter eligibility at this time. And in this environment, it may be more difficult to overcome the 101 subject matter eligibility because of recent Supreme Court rulings that came down. So if you, it's not per se rule that diagnostic is not patentable, but it's just that it's has much higher hurdle now. So as I've mentioned earlier, I will use some example that are directed to CRISPR patents of the two groups that I mentioned earlier. So here is are two patents that are related to the CRISPR technology. This patent, so this is the first page of the patent publication. No, the issued patent. And here, each of the patent are assigned a patent number, which is up here. And the higher the number is, the more recent is the patent. So the date of the patent actually is referred to the date of when the patent issued. So the this is the last name of the first inventor. Here is the title of the invention. So this is in the United States, the ownership of the invention would stay with the inventor unless it's being assigned. So here appear that Fang Sang has assigned his rights of the invention to Broad Institute and MIT. And here MIT and Broad Institute are both the assignee as well as the applicant of this CRISPR patent. In a different scenario, we have 4 inventors in the UC patent, and it appears that each of the inventor has assigned their rights to their respective institution, except for Emanuela Charpentier, who remains as the assignee as well as the applicant. So I wanted to emphasize again that inventorship is not the same as ownership. So what happens if you have more than 2 groups of, or 2 or more groups of inventors that wanted to patent the same invention? Well, prior to 2013, United States is under as the patent system is a first to invent system. So whoever that invented first would have the patent. And after that, America's Invent Act has implemented, then the US patent system had moved to the first to file. So whoever filed the application first will have the patent. So UC started a proceeding called the patent interference proceeding, interfering with naming that the broad patent is basically they should the USPTO, the PTAB, the Patent Trial Appeal Board should allow the patent of the UC to be valid, and the board patent should be invalid because of the fact that they invented first and in the same invention. However, the PTAB and also affirmed by the Federal Circuit had come to a conclusion that there is no patent interference involved, because the UC patent and the broad patents are directed to different subject matter, and that they are not obvious invention of each other. And therefore, those 2 patents are, the patent would still stay valid. The PTAB had decided that looking at the claims as well as other evidence during the proceeding, that the UC patent is directed to CRISPR technology used in prokaryotes, whereas the broad patent, the technology is directed to CRISPR in eukaryotes. So in a patent document, there are different parts to a patent document. There's the specification, which describe the invention and all your data. and support material of the invention. And then there's the claim section, which is what we're looking at now. The claim section is at the end of the patent, and it is a very important portion of the patent document because it defines the metes and bounds of your invention and your rights of your patent. So upon reviewing these claims, then and also additional evidence, the board and also the Federal Circuit had come to the ruling. So as you see that there are so many CRISPR patents that are currently has already issued, you could count on the fact that more controversy is going to is already happening and also will continue in the future. So let's shift gear to take a look at some claims, because since claims are so important, let's take another look at an example. So for example, if you have a chemical compound, this is one way of claiming a chemical compound. You could claim the compound as a formula and a structural formula that's generic in its structure, and you have other additional dependent claim that makes the claim narrower. But in here, the claim 1 is the broadest claim in this example. Here's another example of a patent within a big patent family that's directed to embryonic stem cells and the method of making them, as well as the method of using these embryonic stem cells to, stem cells that are derived from embryonic stem cells, and the use of these stem cells in treatment of disorder. And currently the client had entered a clinical trial for treatment of using these stem cells for multiple sclerosis. So all the patents that I mentioned earlier are all utility patents, and utility patents are also known as invention patent. And invention patent basically would protect an invention, the method of making, the method of using, article of manufacture, or composition. Another type of patent is called plant patent. And here we have a plant patent application that we just paid issue fee and will soon issue as a plant patent. And the subject matter is directed to a cannabis plant. There really are only a handful of plant patents that are directed to cannabis. So we are happy to successfully prosecute this cannabis plant patent for our client. The third type of these patent is called design patent. And design patent protects an invention, the ornamental design, the looks of the invention. So if and it is very popular in the biotech medical field, for example, medical device, even the shape, if your pill has a specific shape, those are also a very unique shape. Those are also potentially patentable in a design patent. If you have an invention, you could cover it using other than design patent as well as utility patent. So you could file both utility patent and design patent. And design patent is actually a underutilized patent type of intellectual property that actually is extremely powerful. So they have, compared to utility patent, design patent is much more economical in terms of filing and prosecution. And it's also offer good protection of your invention. So, and it has a term of 15 years instead of 20 years in a utility patent. But like as I mentioned, you can file both the utility and design patent. The design really protect the look of your invention. So let's say if you have an invention, what should you do and what you shouldn't do? If you have an invention disclosure, you should not disclose your invention before you have a chance to evaluate whether you need to file a patent application, and you should evaluate that with your tech transfer officer or a patent attorney. And what would be considered as a public disclosure? Public disclosure, for example, if you're going to a meeting, you are going to have a poster, an abstract published in a book, and or you have a manuscript that is accepted for publication, and it may publish online prior to it being published in the journal. All those would be counted as potential public disclosure. And if you have any discussion with outside parties that is without an NDA, then that would also potentially be a public disclosure, and it will compromise all your foreign rights. But in the United States, you have 1 year to file your patent application from the date of disclosure, but your foreign rights are compromised. But let's say what happened if you have a time crunch of you need to send out this abstract, you are invited to speak this week, and what can you do? Well, you can submit an invention disclosure for provisional application, which is not being examined with the patent office. And at least you will get a filing date, and within a year, you will have time to convert it to either an international patent application, which is also called PCT, or a US regular application. And as I've done, and as I've mentioned earlier, you could determine the strength of an invention by doing a search on the USPTO website for published patents and application. However, there is an 18 months lag between an application being filed until it's published. So you should bear that in mind. I will close with Walter Isaacson's quote, quoting Emmanuel Charpentier: "At the end of the day, the discoveries are what endure. We are just passing on this planet for a short time. We do our job and then we leave and others pick up the work." Thank you.
Thanks so much, Susie. Really appreciate that with a great material to give an introduction to intellectual property for our trainees. Thank you so much. So I think you're sharing your video screen, but Jason, now would you be able to share your screen?
Yep, I'm doing that. Give me 1 second. You guys see that?
Yep.
All right. So, oops, sorry. So I'm gonna pick up where Susie left off. So there are other types of intellectual property that will come up if you're working in the healthcare and digital health area. And so I'm going to also talk about trade secrets and copyrights. And I'm going to focus a little bit more on the AI side of things. So whereas Susie, I think, was focusing more on the, gene editing side of things, I wanted to make sure that we covered the AI side of things. And so AI in particular is unique in the sense that a lot of the work that goes into the software development and into the selection of the data elements that are going to be used isn't really patentable, right? So software code in and of itself, you can't get a patent on just the code, right? That's where copyright comes in. So really, when you are working in the AI space, what you really need to think about is a more comprehensive IP strategy, right? So patents should not be your primary focus as part of that. So including things like trade secrets potentially or copyrights should be part of whatever your IP development is. And this is something that you're gonna have to think about both at the beginning of the process as well as things evolve, right? Particularly in the AI space. And so it's whoever you're working with, whether it be your tech transfer office, which I'm going to touch on a little bit later, or investors, or your co-founders. It's important to keep all of these sort of IP considerations in mind as you go along. And so trade secrets in the AI space actually is a pretty useful mechanism to potentially protect your IP outside of the patent space. So as Susie mentioned, there are different parts to a patent application. And so what you need to provide to the patent office to be able to get a patent on an invention is enough disclosure to show that you actually have what it is that you claim, but also that people can practice your invention, right? Because a patent is a quid pro quo. You get an exclusive right to prevent others from doing something for 20 years. But to get that right, what you have to do is you have to give people enough information in your disclosure that they can practice what your invention is once the patent is expired, right? And so when we're talking about strategies, patents versus trade secrets in particular, one thing to keep in mind is you need to think about what is it that you want to get a patent on? What do you think you can get a patent on? Is that going to be of any commercial value to allow you to prevent others from being on the market? Because worst case scenario is you file a patent application, you give the keys to your kingdom to whatever it is that your IP is, whether it be AI or a chemical compound, and then you don't get a patent out of it, right? And so what you've done is you've now publicly disclosed all this information, but you don't have a way to prevent others from practicing what you do because you don't have a patent on this. And so again, I would encourage you early on in this process, you really need to think about, okay, it's not just about, can I get a patent? It's what can I get a patent on? And is myself and my company better served by not making that public disclosure and potentially not getting a patent, but giving away the keys to the kingdom, so to speak, for your IP and for your company. So this is where trade secrets come in, right? And so here are some examples right here of trade secrets. And really, I mean, a trade secret is anything that you keep secret, right? And I think that's the hard part with trade secrets, is that once the trade secret gets out, then the cat's out of the bag, so to speak. So you do need to be strategic about what you can consider to be trade secreted. But again, this is a type of protection that you should consider, particularly in the AI space when we're talking about algorithms or the data compilations. So for example, what data are you analyzing, in what order, to spit out whatever it is that you're spitting out? And is that something that people can reverse engineer, or is it only when you disclose it publicly and write it down in all the steps, perhaps in a patent application, will people be able to figure it out? So these are the things that you have to balance when you're talking about trade secrets. And so these are the questions I would say you should be asking early on, particularly in the AI space. Is your idea patentable? Do you have to disclose it? Again, could a competitor come up with the same as you? How long do you need the protection? Particularly in the AI space, things are evolving very quickly, right? And so if it takes 3 to 5 years at a minimum to get a patent, and I think Susie can probably confirm that, where are you going to be in 5 years, right? Is this patent going to have any value whatsoever once it's issued? Or are you moving so fast and you're evolving so much that maybe trade secrets is really the way to go initially, and then you can think about, patenting something later on. So trade secrets, interestingly, there are both federal rights, like patents, but there are also state rights. So there are no state patent rights, but there are state trade secret rights. So there's just something called Uniform Trade Secret Act, which most all states have adopted. And so even if you do not have federal rights, you will have state rights and trade secrets, so you will have some protection there. And then here's a chart. I won't go through in detail the difference between trade secrets and patents. I think the two biggest things, again, to remember are, one is a trade secret is only good for as long as it's a secret, right? So once it's out in the public, whether by your means or some other means, there's no longer that you can get protection. And also the duration, right? So think about, for example, the Coca-Cola formula, right? That's been trade secreted for, I think, over 100 years at this point, maybe 130 years. And so, as long as it remains secret, then it's a trade secret, whereas a patent has a finite life. It's 20 years from the time that you file your patent application. So again, depending on what area you're in, and what type of product you have, those two differences may be part of the consideration that you would think about. For the protection itself, if you're going to rely on trade secret, there are several things you want to do. First and foremost, you want to make sure that any and all disclosures are either subject to NDAs or some sort of commercial contract that prevents any type of use outside the scope of whatever you're hiring the vendor for, or whatever the disclosure is. And that would include the deletion of this information as soon as the person is finished doing with that, using the information. The same thing if you're going to bring on employees and hire them. you want to make sure that your employees don't take the information with them when they go to another company. And there's a lot of cases and case law out there where someone does this, right? So they are an employee of one company, they go to a competitor, and they're taking the trade secrets with them. So there's only so much you can do, but you want to make sure that you got enough restrictions in place, as well as access rights, so you can limit the amount of information that these folks have access to and how they can actually take the information outside the company if they end up leaving. And this would include, policies and procedures, appropriate, security, some type of, significant cybersecurity measures that, really limit who can access certain parts, perhaps of your database, and things like that. So outside of trade secrets for in the AI space, copyrights is also a really good concept to think about and to consider when we're talking about protections. And so, again, the difference between a patent and a copyright, and as Susie mentioned, there's sort of three basic types of patents, right? So there's like utility patents, which means it's useful for something. There's the design patents, and then there's the plant patents, right? And so when we're talking about copyrights, we're not talking about the general idea, right? So what copyrights are giving you is it's giving you rights at the time that you fix something in a tangible medium, right? So the selections, the data element selections, how you arrange the data elements, right? For the algorithm to apply whatever the algorithm is going to apply and to spit out whatever it's going to spit out. Same thing with the code. You can't get a patent on just the software code itself, okay? So when you're thinking about this broader IP strategy, copyrights are going to be important because you want to make sure that you've covered the way that you are arranging and using information through the AI in a copyright manner. So again, just because you're going after a copyright doesn't mean you can't also get a patent, right? So you should protect it on both mechanisms, but you want to make sure that copyright protection is part of whatever your IP strategy is, particularly when you're talking about AI. And when you are working with engineers or other third parties in the AI space to help you develop whatever your algorithm is or code or to put things together, you want to make sure that whatever contract you have in place makes everything that they do for you a work for hire, right? You want to own, you're hiring them to do this. And there's a concept within the copyright law called a work for hire. So you want to have very strong, very specific language in your contracts with your these independent contractors or your employees to make sure that the company ends up owning everything, right? Because the way it works is that if the individual is the one that puts a pen to paper, they're technically the author. Similar to when Susie was talking about patents, the person who comes up with the idea is the inventor. So what you need then as a company is you need a mechanism to ensure that the company itself then owns that information. In the patent space, that's requirement to assign as part of the employment arrangement. And in copyrights, it's making this a work for hire and having them assign all of their rights and anything that they make that's a copyright. So these, if copyright is going to be part of your strategy, you're going to have to make sure that you've papered this appropriately, particularly early stage when you're talking about, working with independent contractors, people you may hire off, different websites or whatever to help you do some of the things on the data side or the algorithm side that maybe you personally can't do. One thing again to consider is whether or not you're using someone within the U.S. or outside the U.S. Work for hire rules do apply differently. And a contract that you sign with someone outside of the U.S. may not give you the work made for hire assignment that you need. So you need to check with someone before you do hire someone outside the U.S. to make sure that you're covered. And then the other thing you're going to want to do is you're going to want to record all the assignments and the licenses and register your copyrights. You don't have to do it, right? It's not mandated for you to do it to obtain copyright rights, okay? A copyright exists once you fix it in a tangible medium, okay? Assignments and recording the assignments and licenses and the registration, what that does is it gives you broader legal rights, okay? So it establishes a legal priority. It gives people notice that this is what you've worked on. And it also shifts burdens for people when someone wants to claim that they made the same thing you did, right? So the way copyrights work is myself and Evan, we could write the same book with the same words at the same time, never have known each other, and we can both get an independent copyright for that work, okay? Where fights come in, and I think this then goes back to what I was mentioning with employees leaving, is where did the idea come from? And so by registering and by recording, what you do is you draw a line in the sand. You make this public, so that way you can prove, you know, hey, I had this idea first, and when this person left, you know, they took this with them, and here's proof of this. So so again, you know, recording and registering is going to be, you know, a really important consideration. And you know, as I mentioned, it's really critical when you're talking about employees or independent contractors that may have information, you know, this access to this sensitive information that they leave to go to another company. Interestingly, in the AI space, there was a US Supreme Court case that actually got decided last year. So in copyrights, there's this idea of fair use, which I'm sure you've heard of, right? So, you know, sampling in music, or, you know, you want to play a 2-second video from like Friends on a TikTok or things like that, right? So there's this idea in, you know, in copyrights that there are some things that are just fair use. You can use like little snippets of things, you know, if you're creating your own work. So in the AI space, right, there's a lot of you know, application programming interfaces or codes that already exist out there, some of which are, you know, are free. And so the question becomes, and a lot of these are, you know, really basic types of APIs that really form the backbone of a lot of software that exists out there. So Java, which is owned by Oracle, they sued Google because they claimed that Google had copied part of a Java API to make Google's own software program. And so the question was whether or not it was fair use or not for Google to do that. And the court actually found that, yeah, it's okay in certain instances like this for you to, it's fair use to use this as a basis, right? Because what Google did was they took the backbone and then they changed it, right? So a lot of people, I think, were a little bit concerned that the Supreme Court has gone a little far on this, mainly because you know, there's no real recognition that you know, you're not starting from scratch, obviously, but you're basically taking someone else's information and you're just changing it, right? And so then a lot of other areas of copyright law, that's not even really allowed at all. And so, but right now, the way the Supreme Court has ruled, it actually loosens up and gives you more ability to make you know, software based on existing code that is out there, particularly for Java, as long as you're making some sort of, you know, significant change to the way the code works. So again, from a copyright perspective, this is actually good news for folks in the AI space, because it gives them more flexibility than to claim their own copyrights in this type of software. Obviously, the backside of that is now people may have fair use access rights to your software, which, you know, going back to the whole idea of, you know, disclosures and patents and things like that, I think this then should give people at least pause to think about, okay, well, is my IP strategy going to be protected, or should I even think about disclosing this, or should I keep this, you know, in-house as much as possible? So I know we had focused on sort of the IP stuff of this in broadly, talking about patents and copyrights and trade secrets. But one thing that is obviously a concern for startups, particularly individual physicians who are kind of starting out with an idea, is cost, right? You have to have money to do a lot of this stuff, right? So particularly for patents and IPs, you're looking at several $1,000s probably at a minimum when you're thinking about filing something and trying to get a patent on this. And so, so when you're talking about, you know, financing, you really need to think about up front, you know, how much is it really going to cost me if I want to file this patent? And then there's a couple of, you know, strategic decisions that go along in that, right? So first and foremost is, you know, what is it going to cost me if I file this patent for myself and I try to get my own patent, right? So that's sort of the first consideration. The second is you may want to see what is already out there in the marketplace and, you know, try to figure out before you go too far down, can I even get a patent on this? And if I get a patent, like what's going to be the scope? And those are, two different types of searches. So the patentability search is really someone's going to look at what exists out there and say, well, it's going to be really hard for you to get a patent, or this is going to be a very narrow patent that you're going to get. Freedom to operate is just what it sounds, is that I have my product. Am I going to be sued by someone else for infringement? Okay. And so, again, up front, when you're talking about IP strategy, it's not just I'm going to file my own IP. It's, what am I going to go after when I talk about a patentability search? And am I already going to be blocked from being on the market, even if I get a patent, because something else already exists there? Okay. Same thing when you're talking about filing for patent application or copyrights, US versus international. The more places you go, the more costly it's going to be, right? So you can file, a single patent application, which they call a PCT, which allows you to go into, I think, over 100 countries at this point. And you could try to get a patent in over 100 countries, right? Each country is going to cost something amount to you. So, again, from a strategic standpoint, you need to figure out up front, what markets do I really care about? Is it just US, or am I going to focus on the major markets like US, perhaps China, Europe, maybe Brazil, South America, things like that. And then the other thing is, and I'm going to talk a little bit more about this, is tech transfer considerations, right? So if you are working at an academic medical center, right, or some other institution, are you obligated to now assign all of whatever rights you have to that entity? And is it then their responsibility to move that IP forward? Okay, so that's also going to play into these strategic considerations, is what you're going to do, right? Who currently owns it? Is it you, or do you have to assign it, right? And how are you getting rights back, right? So, are you going to have to take a license from your institution for the information, for the IP that you've developed, or are they going to give it to you and you're going to own it, right? And what are those terms, right? Is there a royalty that's going to come along with this? Because these licensing terms may impact whatever investment you can get on the back end from certain investors. So when we're talking about, financing, I think these are some high level questions that you really need to think about and ask yourself as you move through. Like, do I need it? Right. A lot of times you're going to hear folks say, well, from an investor perspective, you need a patent, or at least a patent application. But do you actually need it for your business? Right. So the investor push is a different question than, looking at this just high level. Like, do I need this for my business? Can I patent it, particularly in the AI space? Right. What's my patent going to look like? Do I need proof that my product works? Again, as Susan mentioned, utility means useful, right? So you have to be able to show some sort of utility as part of what, when you file your patent application, right? And so you can obviously file it without much information on how useful it is, but there may be limitations if you don't have it. And then, who else is going to pay for it? Do I have money to, and if I do, like, does that change how I think about my, my IP strategy? Do I want to go after, all of these countries now because I have an investor, and things like that. So I, again, from a strategic perspective, thinking about all of these things up front is going to be important from both a cost perspective and from, what should I get perspective. I'll talk briefly because I know we have to get going, but tech transfer offices, they're your friends. So get to know them sooner rather than later if you have an obligation to assign to your institution, because you're going to need them to work with you if you want to move this company forward. And you need to understand up front, does the tech transfer office allow me to create my own spinoff? Am I allowed to own this IP at some point? Do I have to license it? So you're going to have all these conversations, sooner rather than later, because if you're going to start looking for investors, they're going to be asking these questions too, right? Like, what do you own, and how do you own it, and how can you use it, right? Are there limitations on your further rights that go along with that? So one thing to keep in mind when it comes to tech transfer offices and AI is privacy, right? So there's two components of the privacy. There's the actual software and, the combination of the information, right, together. But the bigger thing is the data, right? Who owns the data? Okay. And then this may be a separate ownership than what the IP is, right? So you may have an obligation to assign all of your patent and copyright rights to the institution, but the data may be coming from a third party, right? So who owns the data? So again, when you're talking about these, tech transfer issues, you also need to think about, the privacy and security side, particularly on the data when you're talking about AI and who that ownership is. And this is all going to come into play when you talk about working with third parties, right? So as Susie mentioned, when you're talking about multiple individuals from multiple companies working together, then you can have, you can have multiple inventors, but from different companies. And so when you're talking about collaboration, you need to address, I think, all of these issues, at least upfront, right? What exists now versus what's new, how are you going to handle it? What about someone takes your existing IP and they make an improvement? Who's going to own that, right? How are you going to handle if you guys both have a ownership right in the IP, right? Who's going to pay for costs? Can you license it? Who's going to commercialize? Typically, when you're looking at bigger collaborations in the pharma space, you can probably find a pharma partner who's going to commercialize for you. But then, what are the costs associated with that? Royalties, milestones, and things like that. And then publication rights. And this one I think is important, going back to what Susie mentioned, right? Once something is put out in the public, right, then you could be barred from getting a patent on this if you're going after patent, right? Particularly trade secrets, again, once it's in public, it's gone. And so you may have a partner that wants to publish very soon or very early in the process, but once that's out in the public, then it may bar both of you from actually getting any type of IP rights if you don't get to the patent office, sooner rather than later. And then, in copyright and publications, again, you may want the right to be able to, publish the results to show that you've what you've done, so you can further your career and then work on investors. But copyrights and publications are also going to be important. And then as part of this and collaborations, when we're in the AI space, so now we're in potential FDA considerations. Software as a medical device is a big topic now with the FDA. They're working on guidance they haven't issued yet, but you're going to have to think about potential FDA issues as well as FTC issues, right? So a lot of people don't think about this, but in the AI space, if you've got products out there in the public, the FTC actually has enforcement rights. And there's a separate data breach notification obligation that is covered by the FTC if you're not under HIPAA's disclosure and security rights. So again, when you're talking about IP and collaborations, you need to make sure that you're thinking about the FDA, FTC, and other regulatory issues that may come up, and how you're going to deal with them and who's going to be responsible. And that's all I had. So thank you for your time.
Thanks, Jason. That was a great overview, and I think especially relevant for our trainees who are involved in bioinformatics and AI research. So hopefully that those pointers will be useful as they develop their discoveries and discuss with their tech transfer offices how to protect that property. So our last speaker will be Mary Howard. So Mary, can you share your slides? Great.
Let me see if you can hear me right now.
Yeah, we can hear you.
Great.
Do you want to make them full screen?
Okay, let me make this full screen, and we will get going.
Great.
So thank you very much, Evan, for asking me to join this. You've got a fantastic overview from Jason and from Susie. So this is a different kind of presentation, a different perspective. And what I want to talk about today is about this whole idea of bridging the gap, as Evan talked about. How do you take your idea to industry, right? And some of the considerations about that. The people, as I've done a little quick study about your names, you're from a lot of institutions that have a lot of commercialization going on. And so you're from a background where you've got ideas. And the question for many people when they're doing it for the first time is, like, now what do you do? And a lot of this comes back to what's your objective in this, right? And that's something only you can answer. And it's something that's not easy to answer. And sometimes it's some combination of some of these topics, and sometimes it's not these, it's something totally different. Often it's something that's very personal for you. But those are very important to get clear, because it really makes a difference when you get into this very complex path that you're going to head on to, which is taking your idea into industry and being successful, which is what everybody wants to do. So we had a chance this past couple of months to go back and talk with a number of people from our background, which is creating programs to educate scientists, entrepreneurs, and engineering entrepreneurs in what they're looking for when they're getting going. And so this is some of the things that we heard. And those these kinds of criteria are ones that are super important, because what do? They reduce the chance of failure, they increase the chance of success, and it's very, very thoughtful. And it's going to take a while to get all of the answers for you, because you're in markets that are change a lot. They change because you're in innovation that's going to move along pretty quickly. So these different criteria are very, very important. And one of the things that I would like to focus on today is, what are some of the motivations and the purposes of some of the people that you're going to be involved in? Because that's a really important part of this to know as you're proceeding. So you may be trying to maximize success. One of the parties that we've heard about from Jason and from Susie have been academia, because all of you are affiliated with medical research institutions that have obligations as a result of taking federal grants. They have a public service in addition to the goals of providing education and research to transfer that technology. And there are a couple of aspects of that, and these are not uniform across institutions. That's one of the complexities of that, and we're definitely seeing that among the physician researchers that we are meeting, that people are a lot more savvy about the differences among institutions in terms of who tech transfer is servicing, if it's faculty, if it's students, how much budget they have to be able to support programs, to be able to file patents, and to what extent they're getting involved in supporting startups, as opposed to the licensing of technology through business development. To what extent are the tech transfer offices at universities involved in funding? There's much funding, and tech transfer offices can be great at helping you identify funding opportunities, even if they don't have funding within their own institution. And providing some basic education about the tech transfer process. We're also seeing a change in an increasing demand for the physician entrepreneurs that are proceeding to start their own ventures, the increasing quality of a development plan for your technology, a business model, some financing, and a team. So there's a big delta, right, between you're trying to maximize success and some of the goals of where academics are, and some of the constraints that they're working under, because they have a budget to be able to provide you some of the requirements that they're going to need if you are looking to pursue this as a business. So who are some of the top universities who are doing spin-outs right now? These are groups of ventures from companies that are across this is in the biomed, out of Bioscience LA, if you look at the top 20, you're including some of the people who are in this group today, including SUNY Downstate and some people who have been through the UC system. And Yale is certainly in that group as well. But just be aware of the different goals here. Another group that we've heard about is the financing, right? You're going to have to come in with some money to be able to pursue this. Being an innovation is an expensive undertaking. So there's different places to get money. And one of the things to be aware of is that investors are seeking profits, right? So understand that is a part of the picture of what you have to look at, but not all of it, right? So they're providing, investors are providing an increasing spectrum of services to help physician entrepreneurs move forward with their inventions and to increase the probability of success. And they're a little different, right? The investors understand media is really important. Being able to ensure you're connected to customers and payers is important. But also understand that protecting their business is important. So when you start looking at who are those investors on the pharma side, when you're looking at people who are in licensing technologies, even if what you're trying to do in cancer biology is to license some technologies, you're looking at large pharma increasingly with the number of organizations that have raised funds and raised significant amounts of funds. There are early stage companies that actually have funds to go in and license technology from early stage companies. So in addition to the traditional pharma companies, we're also seeing really early stage companies licensing in technology from academic institutions. And then when you're looking at things like Jason talked about on the AI side, we're looking at some people who were traditionally in the tech space, like Y Combinator, ERA, Dreamit, who have moved into and created health accelerators where they're bringing some money into this. There are also some ones that have more broad spectrum kind of interests, like breakout labs, which are looking for what they call hard science, maybe material sides of activities. And then you also have some hybrid organizations like the J Labs organization nationally, which is both an incubator and a investor, which provides challenges with some funding to be able to support ventures and ideas to develop at the very early stage. Organizations like Techstars and IndieBio are also starting programs that have funding and are interested in taking in return for some cash support, some funding and a piece of equity of your company. So this is making it more complex for you. And one of the things that you're also going to need to do is figure out what's the match. Some of these organizations are just not going to be a fit because of how far along your idea is. Some of them are not going to be a fit because they're interested in a certain kind of technology. So these are things that you'll have to be aware of, but also be aware of that at the end of the day, investors have a responsibility to their organizations that have trusted them with money to invest to return a profit. So that may create some issues with your goals and with those organizations' goals. And those are things to be aware of as you're developing your idea and bringing it to industry. Another party in this are incubators. Now, what are incubators looking for? They need to fill their space. They have space, there's different amounts of equipment and resources depending upon the incubator and the way they're set up. They offer turnkey space, they offer shared overhead. That's very, very valuable to companies that are trying to and will be expected from investors to really be very careful about the expenditure of any cash. They create a community within the incubator and are open into bringing in the community to also network at events. So we are seeing those nationwide chains being put together. Alexandria Launch Labs has a chain of these. Cure has just opened in New York, where we work, and is opening up their systems to global and not just national, but global applicants. And we see biolabs, who not only has a US, but a global presence. So you see these incubators both at a local level, at a state-sponsored level, at a national level. So just be aware of what their interests are and how that's going to fit in with you. One of the things that I would also say is that this is complex. Don't if you are aware of, because of your own background, some of the nuances that Susie and Jason presented in IP, both on the patent side and also on the trademark, copyright, and trade secret side. And that is very detailed and nuanced, and as they both explained, evolving in profound ways with court decisions. Be aware that this is a very complex area, and it's one of the things that happens when it's a hot financial market on the business side, is that that complexity is part of what happens in business. People are going in and they're trying to figure out how to make an opportunity in that. So there will be continued evolution of practices, players, and laws that you'll have to stay on top of. So what we see is this need that you're going to have to be able to navigate this environment that's going to continue to expand, get more complex, get more granular in the focus, and from a number of different purposes, whether it's profit making, whether it's space filling, whether it's tech transfer responsibilities that are taken on by academia. And these are things that you're going to want to have some independent way of navigating. And one of the things that's really important is to be able to surround yourself with people who have an understanding of this broad spectrum of things. It is really tricky to get involved with people who can navigate one piece of it, but don't have a sense of the whole thing, and also are representing which you need to make sure you're aware of where their background is in terms of where they're coming from. One of the places where we fit is in this area of providing first-time founder support for navigating this evolving community. That's where our business has been. And that's something that we spend a lot of time having to stay on top of, and that's all we do, is stay on top of all the moving parts. So we wish you well. We count on you to take these innovations that you've worked on for 10 years, 15 years to market. It's not going to get simpler. It's going to get more complex. We wish you well. Know that there are a lot of people out there who want you to succeed. And just go in with your eyes open about where you are coming from and where you want all the people you're going to need to work with and where they're coming from. Those end up being more nuanced deals than you may have thought initially, and navigating the multiple interests are places where you're really going to want to get some advice from people who you can trust. So thank you and good luck.
Thanks, Mary. That's great, and it's such a practical way to implement the discoveries that they make in lab, and hopefully to translate them through the incubators that you mentioned, including eLab and ABCT and WCBA. So, thanks so much for participating. So we'll move now to a Q&A, and Jennifer will moderate this Q&A. Anyone who has any questions, just type them in the chat box and we'll answer them as soon as we can.
Great, thank you, Evan. I think there's a question in the chat box, and this will be open to all the speakers, from Ryan Preble. He said, I thought most institutions, universities require researchers to sign away invention rights to the university. Assuming Emmanuelle Charpentier signed a similar agreement, how was she able to retain herself as an assignee to her patent?
Yeah, I can take a first stab at that. So, I mean, I think first and foremost, you need to really look at what your university's assignment obligations are, right? So quite often we work with folks that may do certain types of research in their labs at their university, but outside of the use of resources from their university, they may maybe do something different. So there's always nuance and lines there when you're talking about, having to assign to your employer. But I think first and foremost, you need to really understand, what is it that I have to assign? Is it everything, or is it just stuff that I'm, using where I'm using university resources? I think the second is going back to the thing that I mentioned earlier about tech transfer offices. You need to work with these folks, sooner rather than later. It may be that she had an obligation to assign everything over to the university, but she developed some sort of deal on the back end that said, look, I'm going to spin this out, and I want ownership rights. And they may have given her ownership rights as part of some sort of grant back as part of this. And so again, people work different deals all the time with their tech transfer offices, but that's really where this is going to come out. Right. Maybe she has an investor, and part of the investment was going to be having, the right to own this. And maybe the university took, some sort of payment as part of that, right? Or some sort of back end royalty. And there's all kinds of ways that people can work out to get paid, so to speak, on the back end. But you have to have the conversations. You have to know who to talk with. So, again, if you have an obligation to assign to your tech transfer office, I would say talk to them sooner rather than later. Kind of figure out where you want to go, and if there's a way that you can work out some sort of arrangement to move forward.
Yeah, there may be. I could also comment a little bit on this. For the U.S., I think for the most part, the rule may be different overseas in Europe, and although I don't practice outside of the United States, but we do come across inventors that are in Germany, for example, in France, that have different way of cutting the deal. In the U.S. institution, a lot of times you may have a standard agreement that everybody use, but here we have a case that's overseas. I think the situation may be a little bit more complicated, but even if we don't talk about how Emma Charpentier come with the deal, but every time when there is something like this that happens, there is a long story behind it. Like what Jason said. There may be a spin-off, there may be an additional investor, from the patent. All these things, actually, some of this you would be able to see in the, at least in the United States, you would be able to find those assignment documents that are recorded, and you will see who had rights to the invention, and and ultimately there could be a chain of title that Emma assigned it to institution one, or Susie assigned it to institution one assigned it to two, institution two assigned it to three, and three decide to assign it back to Susie. So there would be stories when you see things like this.
I see. Thank you. Does Mary have any comments on that?
Well, I think I don't know anything about that specifics of the negotiation. I think one of the things that I see the physician scientists run into is this whole question of convincing the tech transfer office that you are ready to take a license or even an option on a license. And there's this catch-22. Do you have a plan that they accept? And you know, the kind of 4 things that I mentioned, the development plan, how, you know, including the milestones, right? So you have to get into actually learning what are commercial milestones, not academic research milestones, right? That, so there, you've got to kind of figure that out. And that's not something that they have staff to help you do usually. I mean, that's a big task to figure out what's a commercial development plan for your technology. The second thing is figuring out how you're going to make money on this. I mean, that's a big challenge to figure out how you're going to make money. And a lot of this stuff isn't going to make money for a long time, right? So, you know, figuring that out is going to take a while, and that's on you to figure that out. You being the person who wants to see this thing go to industry. So if you're not going to do it, you got to figure out who's going to help you, who knows how to do that, to work with. And then the third thing is the financing, right? And this is the big, you know, gotcha, right? It's like, how do you come up with money when you don't have something that's working or making money, right? And then of course, you know, when you've got something that's making money, you know, you don't need the money, right? So you know, you get this classic problem of how do you get financing lined up, right? So the shorthand is you just get somebody really famous, and then everybody's kind of cutting their risk by saying the chances are maybe they're going to come up with something. But everybody knows that, and we actually talked to Pfizer Venture Fund, 59% of venture deals are funding first-time founders. So how do you break through that, right? That's a number that nobody expects, because when you meet people, they're always like, okay, who's the big name, right? That's involved in you. So, you know, how do you actually do that? That's a big challenge, right? And so there's all these finesses people do with foundations to get money, and they get internal development funds, and they get SBIRs, and, you know, you scramble money from friends and family, and, you know, you hustle, right? That's what a lot of people are doing, is hustling, getting that. And it's better if you're a neuroscientist or surgeon who's got a bunch of friends who've got a ton of cash than, you know, if you're, you know, an internist for pediatricians whose, you know, colleagues may not make as much money, right? I mean, it's a really random kind of thing. And then the last thing you've got to do is put together a team. So it's really hard if you've spent your entire life becoming a physician scientist and now all of a sudden have first-class business friends, right? I mean, that's not really, you know, typically what you've got time for, you know, as you're going through residency and, you know, doing a ambitious research project. So, you know, those are the challenges of it. And, you know, I think those are things that a lot of people are trying to help these ideas come forward with, because we got a lot of medical challenges, right? And the question is, how do you you know, close those gaps so that you can get people comfortable, because it's not going to be resolved. People aren't investing in zero risk deals. How do you get people close enough that you can actually get moving? And how do you get comfortable personally that this is going in a direction that really is meaningful to you? So I think those are like challenges that we see people run into. And you know, so much of this is kind of counterintuitive, that despite the fact you've got all this fantastic training to do all of this, it comes down to like who you are and being really in line with what you say you want to be, because that integrity is a huge factor for cutting risk from the perspective of other people joining you as a team member, funding you, spending time, which is probably going to be unpaid, to work out your development plan and help you figure out how you're going to make money. So, you know, it's really, you know, kind of refreshing that it comes back to you, and you're figuring out what you really want to do. I mean, it all kind of lines up at that point to me.
Well, that's great. I think in terms of emphasizing what are some of the most common challenges you've seen physician scientists encounter would be one, is just to get buy-in and invest in maybe earlier stage ideas or even discoveries that they have made. Are there any other challenges you guys see as another, some of the top issues that you've seen physician scientists encounter, in addition to the ones you mentioned already?
Well, I mean, I think, IP ownership is big. And again, that's why we've emphasized going to your tech transfer office, right? Because I think typically investors are going to want to know what your IP portfolio is. I think the other thing that at least I've seen, and this is more really on the regulatory side, is making sure that you've at least thought through an issue spotted where to the first couple of times you're presenting, you're not getting caught off guard with well, hey, how are you handling HIPAA? And you're like, I got to handle HIPAA, so I think at least having like a high level thought process conversations with colleagues or other folks that have gone through this, so you can issue spots, you've got some sort of understanding. It's like, yeah, I know this is a problem and this is how we're going to deal with it, or this is how we're thinking about solving it, something along those lines. Because if you show up and then they spot like 10 issues and you're like, oh, that's a good point, and then you don't really have like any type of answer, I think it makes it more difficult sometimes to kind of move forward with that stuff. So I think that's the other thing, is just thinking about your business, right? I mean, this is going to be a business, and so you really have to change your mindset. And I think that's where Mary Howard and her group really help folks, right? Is that they take these folks that are like, I got a great idea, but they're not thinking about it from the business side. And these are all the questions that are going to be the issues for them when they go through the investment side. Is most people already think about IP, but they don't think about the back end of this. Like if you're AI, like who owns your data, right? And how are we going to use this going forward? Like, do you have the right to? So those kind of practical business questions that will, help you launch and commercialize the product. I think that's where, I've seen a lot of these folks kind of struggle, because it's not in their radar, but it should be.
Great. Active question regarding genetics. So I know Susie spoke about the hot area of gene editing and CRISPR. So obviously gene editing doesn't exist in nature in human cells. And so to be able to do that, that's a human ingenuity there. But what about with the growth of DNA sequencing and more people being sequenced, and now we're able to identify new genetic variants, and also another growing hot area is somatic variants, where these can influence outcomes in people. So are any of those discoveries patentable, or is it, unless you're able to say, well, I can create some sort of therapy for that somatic variant that influences outcomes, that you would not be able to just patent a somatic variant that you find to be able to influence a particular outcome in humans?
So that there is no blanket rule to say, you cannot patent mutants. If they occur in nature, then there would be a bigger hurdle. But so somebody who will help you, who wanted to help you with patenting your whatever you found, you need to have a close conversation with that person and find ways to get around the issue, the problem. So for example, if you add a particular tag to it, you make it, you add a particular label, you add something substantially different, and it's not occurring in nature, then there is a better chance of it getting through. And also when we talk about the claims, so that is how you get through, because in your claim, the way you write it would definitely make a huge difference of something that, oh yeah, we're gonna, my claim 1 is the mutation that occur naturally in somatic cells. Right away, right off the bat, you won't get it, get the patent. But if you add something to it, maybe it's a method that you have a human hand into this, there was an invention involved that nobody think of, and then you add that thing into it, and it was teaching away. It wasn't even, people won't think of it that way, but you did, and people won't add that tag, but you did. So those are ingenuity that when the person that helps you would be able to craft into the claims and then find support in the specification and coach the entire invention in a way that that would direct the examiner away from those 101 issues. So it's doable. It's a little challenging. It's tricky, but there's hope.
I see. Or even the analytics that were involved that allow one to identify those variants that can impact outcomes. Like I imagine the algorithm can be patented as well. Is that correct?
Well, so an algorithm per se can't be patented, but what you're saying is that what can be patented is sort of the methodology, right? And so kind of following on what Susie said, like there's a Supreme Court case that says you can't patent genes, but what they did was they left the door open for modifications, and she said that don't exist in nature. But it's a really hard area, right, in this because worldwide there's a lot of folks that think none of this stuff should be patentable, right? But I think going back to strategy and working with someone sooner rather than later is sort of the important point, right? Because there are many different types of patents that you can get to kind of fence in what your rights are. So you could say have a patent on treatment of cancer related to some gene sequence, right? So that would give you the right to prevent other people, even if they can make your gene sequence, they can't use it to treat cancer. So the whole portfolio strategy is important, and you should be thinking about this kind of broadly, which is, okay, how many ways can I attack this, and what's going to be the most valuable and most important to me? Because again, patents don't let you do stuff; they let you stop other people from doing stuff, right? So what is it that you want to stop other people from doing? So they either have to take a license from you, or you can just keep competitors off the market. So I think that's the other way to look at this, is that when you've got your idea, like how many different ways can you protect this? And that's where people like Susie come in. Like they can help develop that strategy and figure out, okay, what's more important and what's not important now that we want to get to.
Got it. And just to emphasize, I know there are people out there who are maybe against patenting or whatnot, but at least in the US and other westernized countries and even China, the patents allow investors and pharmaceutical companies to invest in translating something that is not quite ready for prime time or ready for patient care, to allow it to actually get to people. So I would say that is one of the values of patenting, right? Are there other values about patenting like that are not just seemingly or coming off as like being selfish, that you just want to protect something and not allow other people to get on it? Obviously, like that's one issue that allows people to invest in a certain idea or a product or whatnot.
Funding, like a lot of times investor won't even talk to you if you don't have your invention, your good idea protected, either by patent, by trade secret, or by copyright or trademark. So you do have to have some IP strategy, but patent itself, it can be used as a shield as well as an offensively and defensively. So let's say you don't patent something, but because you think you're being selfish, or you just don't want to share, right? You could think that way until you go ahead and do your thing with your product and do your method, and then all of a sudden you found that somebody had a patent that covers what you're doing. Then it becomes a problem, because that means that when you had that idea, but I had that idea first, but nobody cares, because now we are already moved into a first to file system. But then if you have a patent, right, And even if that patent is not, like particularly valuable, but if that person, that other company that is practicing something very similar to what you're doing, talk to you and say, hey, we have this patent, you're doing this, why don't you take a license from me? But then at the same time, you could say, no, I am not practicing what you're doing. I have my own patent. Look at, I have this patent. We have this patent that covers our technology, and I don't think we infringe. And then you could say, oh, these are my patents. I have a whole list of this thing, and then there may be a conversation of cross licensing. It's like, okay, you don't sue me, I don't sue you. Let's cross license and make a deal so that we could do something together. We could both make money. But then, in that point, your patent is not really used to say and go take your patent and go sue everybody. But you protect yourself, you protect your company, you protect your business by having that in at the back and as a defense. And otherwise you have nothing. You got to have something.
Got it. Thank you so much. Yeah, I think Mary raised her hand briefly. I don't know if you still want to make a comment.
Well, I was just going to add, and I think Susie got to it, which is that, as technology gets introduced, people understand new applications of it. So we deal with, these breakthroughs and then increasing complexity after that. And this cross licensing is incredibly important. And historically, that's what's gone on, right? If you look at, what happened with cell phones, initially it was 10,000 cross licenses to get a cell phone put together. Now it's over 1 million. So if you're thinking about the explosion that Susie talked about in terms of the CRISPR licensing, the CRISPR patent increasing numbers, I mean, that's what's going to happen, right? And, there isn't one mining stake in California to get to all the gold. I think part of it is people don't understand when they think about patents as being like this hoarding thing. It's like, it doesn't actually work that way. But there has to be some kind of system for these more complicated products to come together and to continue to evolve, and especially to happen at a quick pace. You need to know what everybody's talking about. So you're going to end up with something, whether you call it a patent or something else, just to even coordinate this. And with what happened with Pfizer and introducing with Moderna, all of this technology at such an incredible pace. I mean, if you had no clue who had what, you'd just never be able to get there, right? I mean, you just can't get out the gate. So I think it's a misunderstanding. And I've had those employees work for me who really didn't want to patent anything they came up with. But I think when you're talking about things that are complex and moving fast and continuing to evolve, you gotta figure out, what everybody's got somehow.
Right. And try to safeguard that so potentially can help yourself in the future and even others to move something novel towards patient care and whatnot. So great. Thank you so much. I think we're actually at the top of the hour for the session, but.
Yeah, Jennifer, I was just saying, Ryan had one quick question, I think, about how universities could offer resources to students to pursue commercializing their ideas. I don't know if we have a quick final comment from maybe Jason or Susie about that.
Yeah, I mean, so actually I worked on a panel last fall with Mary called the Valley of Death, where, this was a topic with a bunch of folks in both the investor and the university side. I think, universities are increasingly seeing the monetary value and having, tech transfer offices and supporting folks to spin out companies. So I think that is definitely on the increase, more so than it was in the past. So, you, again, talking with your tech transfer group is going to be important to understand what kind of resources they have, because some of these are now working directly with certain investors or investment groups. And so, helping to, bring out companies collaboratively like this. And so I think you see more of those collaborations, but you also see a lot more investors like Mary was talking about on the incubator side that exist out there. And so, yeah, but I think universities are trying to increase the amount of support that they give to these entrepreneurs, because they really see, there's a huge potential monetary value there for them.
Yeah, and Ryan, I was just going to say that at our own institution at Weill Cornell, some institutions have their own internal incubators, like the BioVenture eLab, and Northwell Health has one, and Columbia has one, and I think Mount Sinai has one. And so your own university might have its own sort of small incubator type network where you can meet tech transfer representatives, and then go to a bigger version of that, like eLab NYC, like Mary runs, where it's much more dedicated and much more longitudinal with more mentorship. And so that might be a good strategy if you have an idea that you want to bring to market. All right, well, yeah.
Oh, and speaking of which, I want to invite everyone here to see if they can join us at the annual meeting. And this was kind of a good pre-session before the annual meeting, where we will have people who are going to speak about their discoveries on gene editing. So Seth Katharison will be there, and Janice Chen, who is a protege of Jennifer Doudna. And Jennifer Doudna certainly has spun out a lot of companies, and she's like one of the board of directors for Mammoth Biosciences. So they'll be speaking about their projects, initiatives, and things that are coming down the pipe. But thank you so much to all of our speakers today. Very helpful, insightful pearls. And I guess like the biggest theme is like talk to our tech transfer office, like get to know them early in the process. It's kind of like the overall gist that I get from this, given the complexities of intellectual property.
Yep.
Great, thank you,
Good luck
everyone.
to you guys.
Thanks so much.
Thanks, Evan,
Thanks
for
so much,
organizing.
Yep. Okay.
All right, take
Thank
care.
you.
Have a great rest
Take
of
care,
your
guys.
weekend.
Bye.
Bye.
Thanks, Evan.
Thanks, Mary. Always great. I feel like I'm reversing things where you come speak to us. So thanks so much.
I know,
Yeah.
I love it. Thank you for letting me have a chance.
Of course.
To talk.
Yeah, my pleasure. We'll do this again.
Okay.
Okay. All right.
Okay.
Bye.
We'll see you. Bye-bye now.
Have a great weekend. Okay.
You
Bye.
too.